So with any new type of visa that does come through, when we don't have anything more than generally just an announcement from the minister, we are going out there looking for bits of information that let us know as to how it's going to work, who's going to be eligible for it, and all those little tiny questions that people keep coming to me with. And I've had hundreds of inquiries in the past week with a number of questions. And I've tried to answer them how I can, but a lot of it just does come down to what the wording is going to be in the official rules when they come out. What we do see, though, is these little leaks of things that come out of Immigration New Zealand, little teasers of information which perhaps we weren't meant to know yet. The Minister referred to this as jumping the gun, or when we did see the visa being sort of pseudo-announced to some degree. But we see perhaps as Immigration New Zealand, or at least some of the staff there who do an amazing job, wanting to, I suppose, unofficially help those in the community, those migrants out there, just to know now a bit more information about what's going to happen, rather than waiting for the official full rule set to come out. Now, we do expect that to come out in the next few weeks. Sometime in October is what the indication is, but I've sort of lost trust at times with the minister in providing things on the dates or in the months that they said they're going to be provided. So we'll sort of work with what we've got so far and try and provide what information we do have. So what we've got here is the a knowledge board, was it? I don't have the name here. A set of documents that was created for Immigration New Zealand staff to give them more information about the new, what they're calling the S6 visa, and we'll go through why they're calling it that. This was leaked temporarily online late on the October the 6th. Thank you to Mohammed for letting us know about it. And we've got a copy here in the Google cache to look through. You've probably seen it. If not, I will provide a link to it in the description below. And we'll go through it today. We will point out a few of the highlights in it. We won't go through every single line because it is quite long, but we'll pull up some things which are new information or are interesting to some degree. I will try and scroll through it relatively slowly. So if you want to pause it and sort of look at what's on the screen, that is fine. Otherwise, yeah, do the link in the description down below. Introductions. My name is Arran Hunt. I'm a partner here at Stace Hammond Law. It is 10:30 a.m. on Sunday, the 10th of October, 2021. I actually recorded this video yesterday, but afterwards I just didn't feel that it felt smooth. It just didn't feel like a good recording, so I've just sort of scrapped that. Let's do it again. No script this time. Just going to look through the document with you and see what's in there. As always, if this video is useful to you, please like it. Please share it, please subscribe, click the bell icon. We have just made a change to the Facebook website, the Stace Hammond Facebook page. I'll link to that in the description down below. We are looking at doing some live Q&As on there on a regular basis. So please go and follow that page, and you'll see when we're going to do these sessions, you can come and get involved and also talk with you people live on Facebook. Okay, now it's going to share my screen so you can see what we're looking at. This is it here. This is the S6RV. This is the knowledge base page. This was captured by Google October 6th at a few minutes before midnight, before October 7th. It was soon removed, but we do have it here. Now, this, of course, isn't an official release. This may be up at some point in the future. We hope it is up shortly, but so we can't sort of say that everything on here is correct. There is a number of points on here. You'll see that quite often they do write in here that they're seeking advice from the minister as to how certain things are going to work. So they themselves still don't know how this is going to play out. It's up to the minister. One comment here is regarding the name S6. Now you'll see further down here, these links just link to information below. So that's why I'm scrolling through them fast. You'll see here they initially called it the S3 RV, meaning settled, scarce, skilled. So the letter S 3 times, so hence S3. The actual name they're going to hear is the S6 2021 residence visa category. Now the reason for the S6 is that if you look at the operational manual, so the rules books, rule book, let's just reload that, you'll see that the S category is for special category residency visas, and you'll see there is no S6 category here, so this is where it's going to be put in, we assume. So this will be the S6 residence visa, and that's why they're going to call it that here. Because the one-off residence visa just didn't sound right. 2021 residence just didn't really feel right. I think S6 is actually a good name for it. And when you see ICC, that means Immigration Contact Centre. If you call up immigration and you get someone here, their answers to answer, to get an inquiry as to how things are going with your application, that is who you are calling. So this is generally aimed at them, but also other people at immigration to give them a heads up as to how things are going to work. Now, you know that, of course, it was announced on the 30th of September. We announced it a little bit before then, or the day before. We got pretty close, I think, to what it actually was in our video. And of course, yeah, the first stage of applications will be on the 1st of December. Now, they're calling it stage here. They call it phase in other documentation. Where we call it first phase, second phase, they're calling it stages here. But the first one's 1st of December. Next lot, which is the major group, will be 1st of March. Now, I have had a few questions as to whether people can expect to be notified by immigration if they're in phase 2. We're saying probably not. They have said that they will contact those who should be in phase 1 in mid to late October. I think late's more likely, but we'll wait and see. If you are in phase 2, they may not contact you, just work out whether you are eligible. And if so, then if you're not phase 1, you're in phase 2. We have been through several times as to how the phases work. Generally, if you have an SMC application that's awaiting allocation or it's been allocated, or you have a residence from work application, or you are in the EOI for skilled migrant and you have children who are 17 and older, then you should fit into that first phase if you meet the criteria for being eligible. Otherwise, you'll be in the second phase. And of course, it's 110,000 principal applicants plus their dependents and partners, and that's 165,000. It's actually a little bit lower than we thought it would be with 110,000. I think more people out there actually have partners perhaps than these people in immigration or the minister realizes. But 165 is the figure that they've come up with. Now, they're still working on the conditions of the visa, but we'll know by the end of October, they're stating as to what the conditions are going to be. That's the operational manual changes, which you'll hear me refer to a lot. In this video, when I do say we don't know yet, but we're waiting for the rules, we're waiting for those. The operational manual changes, which of course is this thing here, which has all the residence rules in there as to how things work. Okay, so also the instructions. Instructions means rules, means operational manual, that is the same thing. These links here we've linked to before in our previous videos. They are all on our videos and on the immigration website. This one here, the eligibility test, is broken in that if you have a CPVV or have applied for CPV or will apply for CPVV that makes you eligible, you might not, that system requires you to have applied for a visa already, and we're the way it's worded and the dates, it may cover those who haven't applied yet, but that system doesn't seem to show that. So we're waiting for clarification on that. The application fee. Now, we've said a number of times that we were thinking it would fall below the SMC application fee just because it is a simpler process. Now, according to this, it's going to fit in between SMC, skilled migrant, and residence from work, and fit in between those two. Now, skilled migrant is $2,710, where residence from work is $1,800, so somewhere in between. And we always thought it would be around the 2,000, low 2,000 marks. So that seems to be where we're sort of correct and where it's going to fall between. Now, if you have applied for a skilled migrant and you have paid the application fee, the 2,710, then you'll be looking at getting a refund because they will transfer your fees across to the new visa and you'll get a refund of the difference. If you've applied for a residence from work for $800, then you have to pay a bit extra just to top it up to what the fee is going to be. So I'm going to scroll down. Age limit. So with SMC, there is an age limit. There's age limits with most residence visas, at least ones that you get through work. Here, there is no age limit, which is great for my clients who are past the age of SMC, but are still here working. Excuse me. But there is an age limit when it comes to dependents. So that is not an open, there's no limit whatsoever. There's no limit for the principal applicant. but there is for dependents, but it's not the usual age limit. We'll come more down to that later on. They go into more detail about that because there's a strange situation created by this long delay we've had with SMC and with RFW. Okay, so with the eligibility, yes, you have basically two pathways there. There's a CPVV where you come into this country as a critical health worker or other critical worker with more than 6 months of right to work. That's an allowance if you're here by 30th of July 2021. The main criteria for most of you, I'll quickly cover this because I've covered it previously, is that you have to be in New Zealand on September 29th, 2021. That was a Wednesday, a week and a half ago. And then you have to meet one of three criteria. You have to meet the skilled, settled, or scarce. Now, you can be in Australia if you got caught there and traveled between those dates. They are going to allow that because of the whole problem with people getting stuck offshore. Now, coming back to this here, you have settled, meaning that you've been here for at least 3/4 of the past 3 years. Now, we're going to cover a bit more of that in detail further down. Skilled means that you are being paid $27 per hour or more on the 29th of September. I've had a number of people come to me that were concerned because they had a pay increase not long before then and worried that perhaps immigration might see that pay increase as being not genuine. They could be, no, that it was done for this purpose. It was backdated or predated as to when it was actually took place. Remember that we have in this country several million people who are working, and most of them will get a pay review every year. And so you break that down by month, you're looking at hundreds of thousands of pay reviews taking place in September. So it is extremely likely there's going to be a lot of people who have actually had a pay review in September, possibly on the 28th of September, that put them over that threshold. Immigration New Zealand know that. They're not going to look at you and go, you had a pay rise just enough a week before. It means you're fortuitous, you're lucky, it's a great situation. Don't be concerned that you're going to look at that and go, this looks dodgy, because just the statistics alone mean that a few of you will be in that situation. I've had several clients who are in that situation. It's great for them, but don't be concerned about immigration seeing that in a bad light. The last category here is, of course, scarce, in that you fall into one of these lists, where it's the long-term skill shortage list. There's the primary industries list. There's the critical health workers list. There's several lists linked on this page and linked on other pages that you can go through. We'll have a word about some of those later on as well. The eligible visa types. Now, the way the Minister has explained these is that these are visas where the primary focus is work and it's not a short-term visa. We have concerns about that because if you look through the not eligible type, you'll notice that students aren't. We'll come to those in a moment. Working holidays aren't. Fair enough, that is a visa based on people having a break in New Zealand or a short term in New Zealand. But there is no partnership visas on there. So partnership is a work visa, going from partnership to being a worker, with a student, with a number of different people, where we would see that that person's right to work, which could be a 3-year right to work, as being their primary focus is work, not sort of supporting their partner. We think that's just a bad way of viewing it. So we think that partnership visas should be on the list. Now, you'll notice they're actually on neither list. And we've had no confirmation from the Minister as to whether they will be included in the eligible visa types or whether they won't. For a number of people we've talked to, they are the partners of students, and the students studying, but the partner could be working in one of these scarce areas. Notably, a lot of them are working in critical health areas, so they're nurses or they're working with aged care. So if they're seen as being here to work, then they should be included. But if they're seen merely as being the partner of a student, despite the fact that they're working, paying taxes, doing a great service to this country, working in these very stressful places, then they're not eligible. So that's something that we need to get cleared up, because partners is not listed on either list. The same thing goes with students, especially those who are doing high levels of PhDs and perhaps masters, where they have a right to work full time. The Minister's assumption is that if you are a student who has a right to work full time, your primary focus is study, which might not be the case. You could be a student whose focus is work, But of course, because you can't work, you can't study a PhD on a work visa, you need to go to a student visa to allow you to study while you work. It does not mean that your focus is study. Your study could be there to emphasize, to assist, to grow your ability to work. So I think that's also an area where we're working hard with a few people to try and get that fixed, and at least get students who have a right to work full-time. Of course, this requires full-time work, 30 hours more per week, to be pushed across into this eligible list. And seasonal work, where basically it's, again, looked at being short-term workers. They actually specifically state twice that PhD students and master students who are eligible to work full-time are not included. So they're very adamant about that, but we disagree. And yes, these special trade visas won't be included. Okay, looking down. Now, if you have applied for an eligible visa prior to the 29th of September, it hasn't been granted yet, then as long as that visa does get granted, then you will be eligible as the 29th of September because you have applied for it. Now, the question here is, what if you have applied for a variation of change prior to the 29th? And say the variation is you're eligible both before and after the variation taking place. They're saying here that they're waiting for final immigration instructions to answer this. Our view is that if you're going to be eligible for an application that hasn't been processed yet, then you should be eligible for a VOC that hasn't been either, especially if you are eligible both before and after the VOC taking place. So I'd be surprised if this was a no when this one here is a yes. Now, same here with the reconsideration. So reconsideration of VOCs here. This one here was actually, sorry, about becoming redundant from a job. If you haven't found a new job yet, they're waiting for instructions on that. And this one here, I can understand why they're waiting for instructions, because the wording has always been, at least from what we've seen, that you have to be eligible on the day, the 29th of September, and eligible on the day you apply. There's no requirement, at least from what the minister has said, to be eligible throughout that period. So they're asking the minister for confirmation about that. But yeah, so sorry, for VOCs and reconsiderations here, we think that they will be the same as the one up here, where they are counted as long as they do go through. If they don't go through, if you apply for a VOC and for every reason it is declined, perhaps they go, well, it should be a full application rather than a VOC. If you're still maintaining that first job, then you have been eligible possibly throughout that period. So yeah, this one here, I think that should be the same as up here and should be eligible. Moving on, starting to just leave a bit. Now, if you are on an eligible visa, you meet the requirements on the 29th of September, but your circumstances change. So you lower pay or no longer a scarce role, you are not eligible. They say here that they have to get further instructions. I am surprised about that because the rules are you have to be eligible 29th of September and when you apply. If you're not eligible when you apply, you cannot get the visa. So I think this is actually a fairly simple answer. If you don't hold one of these visas, then you don't have a right. You have to look at other residence pathways that may be available to you, which right now are zero, effectively, with skilled migrants continue to be on pause until at least August next year. So you're looking at, two and a bit years on pause, 2.5 years on pause. There is no other pathways. So this mention of other pathways, which we've heard the minister make several times, it's a bit of a joke, really. Section 61. So Section 61 is when you apply for a visa when you are here unlawfully. So it could just be as simple as, it happens more often than people think, people forget to renew their visa. They go, oh my goodness, my visa expired 3 days ago, panic, come see Arran, all good, we'll get it sorted. We apply for a Section 61. And typically they go through fairly smoothly. It can take a little bit of time, but they go through, visa gets granted, and they've fixed their situation, not an issue. Now here, they will allow a Section 61 work visa as long as the person held another eligible visa type within 6 months of being granted a Section 61 visa. Now that means 6 months before. So say Arran's client on 1st of January 2021, no, a little bit further than that. We'll say 1st of August 2021, their visa has expired. They come to see Arran the 2nd saying, hey, I forgot to renew my visa. We apply Section 61, and then it gets granted, and we look at, okay, it's been only 2 months between you coming unlawful and the visa being granted. You're fine, you fit into this, you're okay. Problem being is that these visas, if there is an issue to be resolved, or if Immigration New Zealand is waiting for information from offshore, perhaps they've gone to security check from someone offshore just because of the person's from a certain country or region, which happens, that could possibly take 6 months to process. So somebody applies, they miss their visa expiry, apply the very next day, 61. 6 months and a day later, the visa gets granted. They're not included in this because it's been more than 6 months since their previous visa. So this should really be changed from being granted a visa to having applied for that visa. That means that otherwise they're going to be sort of punished for any delay that might occur that could be outside of their hands, well, definitely outside of their hands, but also outside of immigration's hands. Immigration are waiting for, say, a security check from offshore, which can take a long time. Okay, that's there. So previously held a visitor visa, eligible in being granted a visitor visa, so no, you're not eligible because visitor visa is not an eligible visa. So here skilled means, yeah, $27 per hour. Now, a thing to note here, just off topic slightly, is in regards to where this figure comes from. So $27 per hour was the figure that was put into place. It was put into place several months late because of COVID-19. The minister delayed it coming through. It's supposed to come through at the start of the year, or sort of January, February, and every year it gets updated to a new figure. Now, the figure itself is released by Stats New Zealand. It is the June 2021 quarter median wage in New Zealand that Stats New Zealand create. It is not a figure that Immigration New Zealand has pulled out of the air. It is actually a figure from an official government agency as to what the median wage in New Zealand was. Now, the median wage for June 2021 quarter was $27.76, so a 76 cent per hour increase over the previous one. So if Immigration New Zealand follow the procedure, which they have for the last number of years, that will be the median wage requirement come February, $27.76, unless the minister perhaps delays that median wage coming into effect until later in the year, which he might, with sort of July, August being a time they're going to have a lot of changes in place with new work visas, this visa going away, other changes taking place. So we could see that median wage increasing early in the year or later in the year, but $27.76 is what it should be. However, just to clarify, this will not, any change to the median wage requirements for work visas will not change this. $27 is fixed. That is the requirement to be considered skilled work. So if you're on $27 and you're relying on that, don't be concerned if you hear about the median wage going up. It will not impact this visa. This is fixed at $27. Now, for those of you who have had pay going down during lockdown, don't be concerned about that too much. Immigration New Zealand are understanding. Of course, they're in New Zealand as well. They are living through this as well. They're working from home. They understand the impact this is having. So if there is a period of lower income, or it fluctuates a little bit, we can make let immigration know about that during the application. They will understand that. One thing I have noticed, though, I've seen this a lot on the forums, is people have been paid just the wage subsidy. Now, that's not what the wage subsidy is for. People, if you are in an employment agreement with an employer, their obligation is to pay you what's in the employment agreement, whether you are working or not. If you can't go to work because of a lockdown, that is not your fault. They're required to pay you what's in your agreement for those hours. If you can work from home, you're still required to work. If you work in a place where you have to be there physically and you can't be there, you should still be paid. Now, there is an allowance, of course, for employer-employee to have a discussion about trying to find a wage level which will let you keep paying the bills, but won't break the employer, because the employer probably won't want to get rid of any staff. They want to get through this as well. But there is no allowance then just to pay you the wage subsidy. The subsidy is there to help them pay you your full wage. And actually, they're required to tick a box stating that they will use their reasonable effort to pay you at least 80% of your wage while they're getting the wage subsidy. So they can't just give you the wage subsidy and say, hey, that's all you're getting, unless you agree to taking just the wage subsidy. And even then, they're actually strictly breaching what they're saying to MSD when they get that wage subsidy. So if that's you, definitely go and talk to your employer or go talk to a lawyer. The employer's creating a big issue for themselves. If you're an employer, definitely go and talk to your employees and try to find a place where you can pay them where it's sort of fair for you both. Don't just pay them the wage subsidy, because you're opening yourself up to liabilities, both with MSD but also with under your employment contracts. Okay, settled. Settled is this whole 3 years in New Zealand, and this is one of the things which is going to be, it's one of the biggest issues people are having for those who have arrived after the 29th of September 2018, but still may have the 821 days. Now, it's going to come down to exactly how this is going to be worded in the operational manual. And we're waiting to see what's going to be. Now, my view is that the cleanest way to write this, as a lawyer, I think about how I would write the rules and how I would write legislation to make it clear and obvious, and so it can't be manipulated. Here, it would just be 821 days between these two dates. Done. That seems to be nice and simple. If they bring in a requirement to have been either in New Zealand on that date or prior to that date, that means that a number of you who perhaps arrived in October, December, January, February, which still hit the 821 days, will be excluded, unless perhaps you came to New Zealand at a previous date. The question being is how they're going to word it that, you may have come to New Zealand for a holiday in 2015, and then you return in 2019, start 2019, you've made 821 days, and you were here before that date. Is that what they're intending to do? It's hard to tell until we see the actual final rules. So for now, we're saying that we believe it should just be 821 days between those two dates, but immigration may require you to have been in New Zealand or living in New Zealand perhaps prior to September 2018. The other issue there is that they're trying to make this a very quick and easy process for them to push through. They have to do this at really a fast pace to get through 100 or 1,000 of them within about 12-month period. If they make these things too difficult for people to prove or people to show, then it could be an issue. Now, they have access, of course, to your travel records in and out of the country, so they can tell whether you were in and out of the country. But it raises, if they're going to start making an argument, well, were you living in New Zealand? Well, there's lots of ways to say that you were living here or residing here is the term. So it gets a bit complicated then. So our hope is, 821 days, but we'll have to wait and see the official rules. But you don't have to actually have been holding a work visa for that whole time. It's just being an eligible visa on the 29th of September and when you apply. And you can even have been unlawful during that period, as long as you, again, hold the eligible visa on that date. And here they confirm that, you may have come to New Zealand for a visit and then moved here afterwards. You may be eligible, but wait for final instructions. So they themselves aren't sure as to how this is going to work. Now, scarce. So scarcity is, on this list here. We mentioned this. So I did the interview with Eric at Stanford, and we did mention the scarcity lists. It's worth having a look through if you don't meet the other criteria. If you're going to apply for this, the easiest one to meet the criteria for is that 3 years, if you have definitely been here for the 821 days and were here prior to that date. Basically, it's going to be you have an eligible visa, you meet that, that's the criteria met. And of course, the usual health and medical criteria, which we'll come to actually later on this as well. The scarcity one is probably the one we would use third. So it'd be the date criteria, then the $27 per hour or more, and then the scarcity list. Now, the reason why we're saying that's last is because it's not clear yet as to whether you're going to have to, or how you're going to show your eligibility for this list. You may have a job that's on the scarce list, that's not an issue, but jobs often have ANSCO requirements. Or if they're on the long-term skill shortage list, they may have the requirements under that list. That list has higher level requirements. So say a chef under ANSCO may require just a certain level qualification or maybe 3 years experience, I think it is, instead of the qualification. A chef on the shortage list requires the qualification followed by a number of years of experience. So it is a higher threshold to meet. Now, we've been hearing word that they're not going to be enforcing the requirements for the long-term skill shortage list. So if you're applying under the list for those jobs, you won't need to prove that you meet the requirements for that. They will take that from the job description and see how you match that with your experience. Again, it's about getting this thing pushed through faster. If they add too many criteria, too many hoops to jump through, they'll never get this done in time. So they're getting confirmation from that. We've heard from other sources that they're probably going to not meet, they need to meet that requirement. Again, students with PhD students with full-term rights, full-term work rights are not included, and neither are entrepreneurs or investors because they actually have their own pathway to residence. Students don't, sadly, with SMC being delayed so long. And again, the eligibility online, be cautious with that tool. It's reasonably good, but there are some niggles in there that aren't quite right. Police certificates. So New Zealand police certificates will be gained by Immigration New Zealand themselves. We have seen a delay in those currently, taking several months to come through for our clients, and their visas, of course, sitting there in limbo waiting for them. Now, we hope the NZPC is ready to get 100,000 more requests for police certificates within a matter of months, and we wouldn't be surprised if that did sort of delay things somewhat. Overseas certificates won't be required if provided previously with a previous application, unless there are specific concerns. So if Immigration New Zealand are aware that you've had a conviction previously offshore, or an accusation, or they've had an anonymous tip off to them about some activity you may or may not have undertaken, then they may require that police certificate anyway from offshore. They can ask, have the right to ask for one if they want one. For our clients, we're generally advising them may as well apply for one anyway, just in case it gets asked for. You've got it ready to go. Here you go, Mr. Immigration Officer. Can we proceed? Just to keep things flowing through. They generally are reasonably cheap to get, so it doesn't hurt much to get one. Health requirements. Now, if you have had a general medical certificate in the past 3 years with a previous application, you can reuse this one. If you have not, there will be a LMC, a limited medical certificate required, which is a lower threshold. It's an easier test, probably a cheaper test than a full general medical certificate. You will still need to have an X-ray or probably in the last period, and you may have maybe not apply for a medical waiver. So if there is an issue with your medical, there is a chance to get a waiver. We do a lot of waiver work for clients, depending on how serious the health issue is, as to whether it comes through or not. So yeah, here we go. Median wage increases in February 2022. The $27 will stay. The median wage increase will not impact this visa. You cannot apply if you're overseas. If you get the CPVV to come to New Zealand as a critical health worker or a critical other worker for more than 6 months, you must be in New Zealand to apply. So you must get into the country before 31st of July and apply before then. Now, if you are a nurse in New Zealand completing your CAP, you must complete your CAP prior to the 31st of July cutoff date, and then you must get registration, at which point you can apply for this residence visa. You're not required to find a job first. I'm sure you'll find a job very quickly. And again, yes, if you're in Australia stuck there because of the removal of the quarantine travel, then you can apply. Working through. So yes, if you apply for a visa but it was declined, then of course you're not eligible because you did not have an eligible visa or an application that became an eligible visa prior to the 29th of September. Partners and dependents. You can, of course, include partners and dependents. Now, they can also be offshore. There is the usual partnership requirements, which will include living together requirements. We've done the video about living together. Go check that out. You know, if you're unsure about what living together means and the high threshold they're putting in place there. There's a requirement to have lived together for at least 12 months to get residence under partnership. That is normal for all of these partnership, all of these residence visas. However, there is an allowance here under R2 115.5 that will allow you, will basically allow them to put the partner's application aside, grant the main one, and then grant the partner a work visa to come to New Zealand or be in New Zealand to build up the remainder of that 12 months of time together, and then grant them the residence visa. So it keeps it under the one fee, gives them a shot to spend more time with you. So you have 12 months and then they can get their residence. Now, the allowance to provide a work visa under R21 15.5. Now, this is a reference to the operational manual. So R21, so you'll go to here, you go to residence, then 2, then 1, then 15.5. So there's the section here, and it allows here for the granting of a work visa. Now, if there is a right to grant a work visa and the border is still closed, that right to grant the work visa may be delayed until the border is open. We cannot see immigration using this as a way for people to enter the country through border controls when the border is closed. So this won't be an exception. It will most likely be a case where they'll put that application aside, and then when the border opens, they'll look at granting a work visa to come to the country, live together, get to that 12 months, and their residence can be granted. Now, dependent children, typically it is up to the age of 24. As long as they are dependent, they have to be single, have to be dependent to you for your costs, that sort of thing. Here it says here 25 and over, but down here it just says 25. So we're getting clarification whether that means 25 and 26 or just 25. Now, they are allowing an application for people who are 25 as a dependent if they were included in the RFW, the Register from Work, or the SMC application, or an SMC expression of interest, which is great because that's basically it's acceptance that's just taken too long to be granted. So if they've included an application, they're included when they were 24, and that could have been more than 2 years ago. So it could be 26 now. So they will still be able to be included in this application. Cool. Let me rephrase that. They'll be able to apply for residence under this new visa, but it will be in their own application. So need to submit their own application if they are over 24. Now, the reason for that is there's actually an immigration regulation, which is part of the Immigration Act sort of side bits of rules, that dependent children must be 24 or under. That when they hit 25, you cannot be included in a parent's application as a dependent. It's against the law. So immigration are getting around that. Well, the minister is. So instead of just redrafting that law, they're just saying, okay, you can get residence if you were included in the RFW or the SMC or the SMC EOI, but you must apply on your own. There'll be a little tick box to say that you know that situation, which means you have to also pay that fee yourself. So it's going to add to the cost, but at least it does still keep that door open for them to get residence. Now there's some things here about general processing of visas that they're going to try and do it within 12 months. If there's another lockdown, it could impact. They're going to try and do it as well as they can. We do expect, and I suppose immigration does as well, that the majority of SMC and RFW applicants who are sitting in queue are going to move across to this new visa because it's going to be so much simpler and faster to get through. So we would expect most of the SMC staff to, after a couple of months, be moved across to working just on these effectively. So for those of you who are offshore with SMC applications, we believe that your applications will stay on the non-priority queue, which they will not be processed any further, with the SMC staff moving to work on these. As to whether you move from SMC or RFW to this new visa will come down to probably where you are in the process. I think if you're, some of my clients are now basically waiting for the final decision to come through, delayed because SMC is a paper-based system and we're in lockdown. But once lockdown finishes, we're hoping that will be a matter of weeks before their visa gets granted. So there's not much point in them applying for this new visa come 1 December because they may be about to be granted the visa. For clients who are probably several months out from being allocated for SMC or RFW, this will be a much faster process in the long run. So I'll probably look at them and go, well, this is probably a better way of going. But not every SMC or RFW applicant is going to be eligible for this visa. RFW ones probably will be because they have already jumped through bigger, higher hoops to get to that point. But not all SMC applicants may fit into this. If you're an SMC applicant, you may not have a $27 per hour job. You may apply when it was $25.50 or $25. You may not have been here for 3 years. So before you go ditching one to go the other, make sure that you actually are going to be eligible for this new visa. Other way around though, if your SMC application is sort of borderline, you're not sure whether you're going to get it or not, well, you're pretty guaranteed to get this one because you meet all the criteria, because they're much easier criteria, look at making the change. So what we're doing with our clients, we're going to say, hey, over here, it's hard to show the evidence of the experience, or it's hard, or your job isn't the best perfect match for ANSCO. It's probably just it's a good match. It's borderline substantial, but there's an argument there. We might just say to them, look, let's just sort of push that back, move it across, and go for this new visa. So definitely go talk to a legal advisor or an immigration advisor if you're not sure about that, which path to take, and they'll be able to advise you on that. The application process, we haven't got much more information about that. Here they say it's phases. I think phases is a better term. So yeah, 2 phases there. Most will be in phase 2 and 1 March. Some will be on the first phase. And for the phase 1, it's only those who were 17 or older when the announcement was made, or the 29th of September, at least before the announcement was made. So if your child turns 17 the day after, sorry, you are in phase 2 rather than phase 1. Scrolling down, must apply by 31st of July. After that, the applications must be declined. That is what the wording has stated. Okay, there was a confusing line used in the initial announcement from immigration after which the DHI's press release linked to, and it was talking about a right to reside in New Zealand permanently. Now, people took this as meaning this was a permanent residence visa. It is not. Just to clarify, a residence visa is a right to reside in New Zealand permanently. The only part that's not permanent is your right to re-enter the country. So if you get a residence visa under this and never leave New Zealand, you are fine. You can stay here forever. But you can't leave the country and re-enter after 2 years. The PR part, when people talk about PR, that's permanent residence. That's the right to re-enter the country after 2 years. So this is a regular residence visa. After 2 years, you can apply for PR. If you meet the criteria, there's like 6 different things that you can match. For most, it's basically it's being in the country for half the time. Others could be investments, property, that sort of thing. Then you get PR, get permanent residence, and then you have the right to come and go as you please forever. There are some of you who have applied for a residence from work, and a residence from work does allow some applicants to get PR straight away. There is no indication that if you do transfer across to this new visa that you will get that PR straight away as well. We believe you will just get residence, and you have to wait the 2 years to get PR. So for you, if you do have that, you're on that RFW queue, you have a right to get PR on your application. You may want to toss up, is it worth waiting in that queue or coming across to this? How valuable is PR for you? Honestly, if your intention is to be in New Zealand anyway for the next 2 years, which with the border the way it is, that's probably safe for most of us, then it's easy to get PR after 2 years. So you may want to go across and just get residence sorted now, secure yourself, right to buy a house to live in, that sort of thing, right to change job, not tied to a job. But if you are looking at being in and out of the country more, perhaps actually even leaving New Zealand, then you might want to stay in the RFW queue until you've got that permanent residence visa if you're eligible for it. Looking down. So we've covered fees, that you transfer the fee across. Yeah, should you change across, that's a decision for the client to make. We'll advise our client as to what we think they should do, and we'll sort of show the pros and cons to both approaches. And of course, SMC is changing drastically at some point next year. It is locked until August 2022, at which point it will have changed. We will expect the immigration minister's immigration reset that he's talked about to have had some impact by that time, and he will have had a chance to have actually made changes to how this is going to work. And that is it. That is basically what this is. One thing actually just mentioned, which I might have just skipped through there, was that there is no priority when it comes to your application. So the only priority is down from being in phase 1 or phase 2. If you're in phase 1, you're given priority because you have the SMC, RFW, or an EOI with children 17 and above. If you don't have any of those, you're in phase 2. It's the only way there is priority is that way. Otherwise, it comes down to a date or a time of application. So those who submit earlier, faster, get looked at first. If you apply on the 1st of December, you will get looked at first before somebody applied on 2nd of December. Same with the 1st of March and 2nd of March. So we're getting our clients ready to make the application as quickly as possible so they get as high up the list as they can to get this done as fast as possible. The first visas under this regime we think will get done very, very quickly, and then it will slow down as the workload builds up. So we're going for our clients to try and get there as fast as we can, get the applications made straight away to try and get them a better place in the queue, because no matter where you are in the SMC queue or the RFW queue, or no matter what your income is, there is no priority apart from the 2 phases. Other than that, it's just done by date. And that is it. That is our quick review of this. We will leave a link to this in the description down below so you can see what Google cached. Also, yeah, a link there to their Stacey Hammond Facebook page. We're doing our live sessions on there, so definitely go and follow that so you can see when those are going to be. There'll be probably maybe even once a week for the next few weeks while we get the rules coming in, so we get clarity around this, and then maybe once every 2 or 3 weeks after that, just to sort of keep things ticking along. But otherwise, that is it. I'm going to go and spend a nice Sunday not working. I shall probably answer some inquiries. I will try and get to the YouTube comments. Haven't been in the last week. I've been too flat out with literally more than 1,000 messages from people around the world. But we'll get to the YouTube comments as soon as I can. Until then, kia kaha and stay safe.